Well, Justice Sandeep Mehta sir will join by 5, and I think Honorable Justice Karol sir will also join soon, and Justice Polo have joined already, and
Palo has joined.
Ramanathan ma'am
is also there.
Yeah.
Pramila Acharya is also there.
Pramila Acharya ma'am is here. Iram Majid ma'am is here. I think we can wait for a while. We can wait for.
Okay, no problem.
Justice Karol sir have joined, ma'am. Justice Karol sir have joined.
Yeah, good afternoon, good evening, all of you. Please.
Sir, pranam, sir.
Good evening, sir.
Good evening, sir.
What a pleasure to be here with you, all of you, please. Thank you.
It's our pleasure, sir.
Ma'am, I think our chair have joined, chairperson have joined. I think we should proceed because Honorable Justice Sandeep Mehta sir will join. I think we should start the session.
Okay.
Thank you, ma'am.
A very good afternoon to everyone joining us for this session today. I, Parika Gupta, extend my heartiest greetings and a very warm welcome to our esteemed panelists, faculty members, and all our dear participants to the fourth session of International Conference on Mediation 2022. Today's session would be on the role of mediation in family and matrimonial dispute. Before we begin, I would like to introduce our respected moderator for the session, Professor Kiran Gupta, Faculty of Law, University of Delhi. With over 2 decades of teaching experience in family, succession, and property law, as well as law of torts, her valuable insights will further the objective of today's session to have a constructive discussion on mediation. It is an honor to have you here with us, ma'am. With this, I request you to formally welcome the panelists. Over to you.
Thanks, Parika. It's my great privilege to welcome with gratitude all our guests today. The chair of the session, as we know, that this conference was organized, 2-day conference is organized by Faculty of Law, University of Delhi, in collaboration with Delhi School of Public Policy and Governance, which is an institution of excellence of University of Delhi, and the Mediation Committee of the Supreme Court of India. I welcome you all for this fourth technical session of today's conference. We have with us a catena of, or you can say, very good speakers, the honorable members of the bar and bench, who will chair, co-chair, and are our special speakers. Honorable Justice Sanjay Karol, who is the Chief Justice of the Patna High Court, is our respected chair in today's session. Honorable Justice Sandeep Mehta, Judge, Rajasthan High Court, is our esteemed co-chair. Honorable Justice Anjuli Palo, Judge, Madhya Pradesh High Court, is the respected co-chair. And we have 3 special admirable guests, special guests today. Miss Iram Majid, who is the Director, Indian Institute of Arbitration and Mediation, and she is also an IIMI certified mediator. We have Miss Ramanathan, who is a mediator and managing trustee with FCDR. We have Dr. Pramila Acharya, who is an advocate as well as a mediator trainer, state coordinator of Rajasthan. I extend my warm welcome to all of you and the other participants here. In this session, friends, we are going to discuss role of mediation in solving the disputes relating to family and matrimonial matters. As far as we know that as far as family law is concerned, it is not uniform in India. Each religious community has its own law, and the tribal communities are governed by their customary law. Family disputes were rare in earlier times. The reason being that whenever a dispute arose, the members of the family, the elder members of the family, they themselves resolved it by conciliation or by mediation. So as far as family and matrimonial disputes are concerned, mediation is not something which is new to India. It has been happening since long, and it is generally happened by the elder members of the family. But since the family system is changing in the society, due to this change in the society, the families, more and more families are getting nuclear families, husband and wife along with a child or maybe no child, living together, both of them quite young, not able to adjust with the views of each other. It is just a question of adjustment. And some minor disputes, they become so major because there is nobody to bring out reconciliation or to mediate between them in these disputes, which resulted in big matrimonial problems, ruining their life. We earlier had a very good system of mediation, but now, because of all these problems, we need to have, you can say, a formal kind of mediation in family matters. As far as family law is concerned, it is a very different branch of jurisprudence. It is a jurisprudence in itself. To solve a family dispute, just the knowledge of family law is not sufficient. We have to apply the law, we have to apply the sociology, and we have to use the psychology also, because these matters are very, very emotional matters. We just can't discuss this way or that way, because it is a question of breaking the marriage. And the object of the law is not to disrupt, but to conserve marriage and marital relations, because it is useful. Marriage is an institution which is a very useful institution for the society. Society cannot survive without the institution of marriage. And it is because of all these things, it is a very different branch of jurisprudence requiring different kind of practice, different kind of decisions, different kind of emotions. The person deciding the case, the judge deciding the case, or the person acting as a mediator has to judge the emotions of the parties and try to reconcile those problems, try to bring them on the table, discuss their problem and solve them, so that the marital relation will be conserved. Otherwise, it will be a disaster for both of them. It will be a disaster for the families, members of both of them, and it will be a disaster for the children of the marriage. We call mediation as a part of alternate dispute resolution, as a method of one of the process of alternate dispute resolution. But in my opinion, it is the only effective method of dispute resolution. If we have a family dispute and we go to the lawyer, that small dispute will become a bomb and will explode and break the marriage. We need mediators who can console these parties, who can advise these parties, these persons who have small minor differences which they could have easily adjust. Or if they are not able to adjust, it is clear that they will never adjust it. Let the marriage break without any enmity between the parties. So all that is required, that is the need of the hour, and that is how the mediators play a very important role in conserving or peacefully disrupting the marital union. As far as our Hindu law is concerned, presently we are governed by the Hindu Code, Hindu Marriage Act. There is express provision in Hindu Marriage Act, section 23, subsection 2, which provides that the courts must try reconciliation before deciding the case. Whenever they find that there are chances of reconciliation between the parties, they should refer it to the reconciliator. The Muslim law is not a codified law, but if we study it, even in case of pronouncement of talaq, there is a need that there must be attempts of reconciliation between the husband and the wife. And if that attempt fails, then only the divorce can be pronounced by the husband. Now we have Family Courts Act, which makes it mandatory for the family court. And you know, all the matters relating to family fall within the jurisdiction of the family courts now, exclusive jurisdiction of the family court. And before taking up the case, it is mandatory that case must be referred for mediation and conciliation. And in family courts, almost in all the family courts, a mediator is attached, and that mediator is appointed by the district legal services authority. And they try their best to bring reconciliation between the parties. And if it can't be the marriage can't be saved, or there may be a dispute relating to maintenance or custody of the parties, if the parties don't want to settle, then the mediator has to file a report in the court, and then the court will decide the case. So without speaking much, since we have such distinguished speakers with us, we would like to hear you. And I would like to invite our first speaker, Madam Iram Majid, who is the director in the Indian Institute of Arbitration and Mediation, and who is also a certified mediator, to enlighten us about her views relating to role of mediation in family matters. Now the virtual floor is yours, ma'am.
Thank you so much, Kiran. And thank you so much, Justice Sanjay, Justice Anjuli, Uma ma'am, Pramila, and Mr. Ashutosh for inviting me especially. So thank you everyone for inviting me, since it is a very good topic. So as Kiran, you have mentioned rightly that these are the disputes which are highly emotionally charged disputes. So I would like to say that the scope of mediation, if we see in India, is very, very promising, and for bringing up inequitable treatment in a sense of fairness and justice in the society. Mediating skills, especially unbiased communication skills and influential bargaining strategies, are to be engaged. Conflicts cannot be averted. It can be resolved, and conflict can be turned into an opportunity. But every relationship goes its ups and downs. And especially in matrimonial disputes, there are a lot of ups and downs, because in this session, we are discussing about the role of mediation in family matters and matrimonial matters. So I'll be telling you I will be highlighting the benefits of mediation in these kind of disputes. And then I'll be discussing one or two my experience in my mediation, where I have done 2 cases which are highly emotionally charged mediations, and then certain recommendations and suggestions for the panelists and others to look into it and to bring a roadmap regarding the such kind of disputes. So as I told you that every relationship goes its ups and downs. And if you talk about divorce or reconciliation, see, these both are very, very personal and common phenomenon globally. Either it is reconciliation or separation, mediation plays very, very important role. If parties are going for divorce, and then it can be analyzed as a decision to leave the partnership and end the marriage. So however, they can be preceded by a long process of ending the relationship. There may be a lot of other things which can be, subsequently some other disputes may be attached to one main disputes, and which can include estrangement from the spouse, stress, conflict, and even violence can be involved. So such disputes involve high emotions, other spirals, along with other connected matters. So according to Robert Ware, behavioral disorder in children of estranged marriage face difficulties in dealing with the opposite sex and suffer poor academic performance, are often in the long-term nature which can be a disaster, which lead to family if we will not able to handle these disputes timely and in litigation, if we are taking this dispute in litigation. So we can counter all these aspects if matter will go for mediation. So if one dispute, like you can say a divorce petition or divorce dispute or the family matter or the matrimonial dispute, so the kind of other disputes attached to it may be that the parties want to go for the decree of the nullity of a marriage or declaration of the validity of the marriage or the status in the matrimonial status of any person, suit for proceeding between the parties to a marriage concerning properties of the parties or either of them, suit of property declaring proceeding or the declaration of legitimacy of any person, or the suit proceeding for maintenance, guardianship, custody, access to minor, all these things. See, all these are connecting disputes which one disputes, and if you see, if you able to settle one dispute, you will be able to settle all these disputes, all these issues in one go. So mediation will decrease the burden of the court. We only calculate that one case has been decided, but one case has been settled. No, it is not one case always. When it talks about matrimonial disputes, it always a bundle of cases, bundle of disputes, bundle of emotions which we settled in one go. That is called in matrimonial disputes. See, all disputes are very, very closely connected. And technically in mediation, as I told you, 4 or 5 disputes we can settle in one go. Now, if we talk about the pre-litigation mediation is the way forward in this regime. As we know, at the case Srinivasan Rao, where the Supreme Court discussed the idea pre-litigation mediation in the context of family disputes, court acknowledged that the dispute arise due to trivial reasons that are solved by pursuing litigation. It was also observed that the data, the data from the Delhi District Court shows that chances of successful resolution are higher when the party approach to mediation at earliest instance, not wasting the time in the court and then you will be going for the mediation. Then it may take a lot of years and years. So pre-litigation mediation is a way forward in this regime for the mediation. And even if you see that the B.S. Krishna Murthy case, in this Justice Markanda Karju held that the lawyer should advise their clients for mediation, especially when the dispute is family in nature. Otherwise, the litigation will go on for year and year, decades and decades, which will be detrimental for both the parties. So these are the benefits which in one go you can resolve all these disputes and all. And but these benefits can be accrued to you, and you can be able to get the fruit of this mediation in the family disputes only when the mediators are trained to handle the emotions well, because these disputes are highly charged emotions, and just a basic training, after acquiring a basic training, it may not be possible for you to handle the emotions effectively. Because if you take the commercial disputes in one hand and matrimonial disputes in one hand, skills are required for that, but emotional handling of emotions and treat parties with empathy is something which you need to learn, and you need to have extra edge on that. And because these dispute required certain special skill set to handle. I can share you one of my case when I was doing mediation in Delhi High Court. So there was a dispute where both the party, they were having a partnership. And this case was having 2 aspects, commercial aspect also and relationship aspect also. So they were having a partnership. They both were partner in one business, and they fall in love and they performed marriage. After this marriage, the girl was from different faith and boy was from different faith. They converted into one faith and they performed marriage. After that, they had a baby. After baby, 3 of them converted into another religion, the religion of one's spouse. After some years, the husband converted back to another religion. See, this was a change of religion for one religion to other religion, another religion to other religion. And then that dispute came before me, that how to resolve this dispute, what would be the religion of the child, and how the child will be brought up, what would be the custody of this child, how the business can be, business issue can be resolved between these 2 parties. See, I get a goosebump when I tell you about this case, because that case has 2 aspects. One is commercial and one is relationship. When we talk about the commercial, it was very, very easy to resolve, just 50-50% of the, they said, okay, 50-50%, we are happy to have that. But when it comes to emotions, it required special skills. It required, to treat the parties with empathy, with compassion, and use different set of skills, some sort of, you may say, hypnotic languages or metamodal stat and all. So it required a different altogether skills. In one case, I learned a lot. And then the outcome was so miraculous, so miraculous that no court can come up to that outcome. And with this, I learned a lot, and I come to know that, look, same party, having the same perception, same mindset, but the outcome for the two, and when they were on the two different aspects, one is commercial and one is relationship issues, they were completely different person, altogether completely different person. When they were dealing commercial, they were completely different person, and when they were dealing emotions, they were completely different persons. And there the role of mediator is very, very important, because you have to be the navigator. You have to be the navigator of their emotions. If at one instance you are unable to handle their emotions well, you may lead to disaster of the parties. We know that we have mediations, we know we have mediation cells, we have institutions and all, but what is the most required thing is, in this kind of situation, that we need to have more skilled mediator. And one thing also I would like to tell you, one example. See, recently in the COVID days, when I got COVID, so one person used to visit my place for all the tests and all. He was very, during that days, he become a family member, like, because every other day, all the family member were into the COVID. So he used to come for having our test without any, inhibition and all. So recently I called him, and he called me and he said that I'm having some matrimonial issues, and I'm going for mediation. I suggested him that should go for mediation, because he had 2 years old child. So don't, immediately go for case and all. So go for mediation. But somehow, because of my traveling and all, I could not assist him in the mediation. But last week only, he came again to have my one test, and I saw, you will not believe, I saw he wrapped what you called a handkerchief around his neck. But somehow that handkerchief, got displaced when he was talking to me, and I could see a very big mark on his neck. I said, what is this? And he said, there was a fight, and my wife has strangulated me with this. I said, but you went for the mediation. He said, yeah, I went for the mediation, but it was not successful. I said, why? Because the mediator was unable to understand the underlying interest. They were unable to understand underlying interest. I keep on saying they did not believe, and situation become more worse when we came out from the room. So that's what I would like to say, that we need to have a special skill set to understand the emotion of the parties. We cannot miss out on any emotion in this matter. And if I say to all of you that there was a survey conducted in New York, they said, okay, suppose if there are, you have to scale on 5%, that how much negative you need to stay in a matrimonial, tie-up, or how much positive you need. So there was a different answer, but the answer
Parika?
Yes, due to some technical glitch on ma'am's part, I would like to continue with this session. Nonetheless, it was a very comprehensive, holistic, and solution-driven session drawn by ma'am. So, thanking you, ma'am, for taking the discussion forward. And now, I would like to welcome our special guest, Ms. Uma Ramanathan, to share her views on the topic. We humbly welcome you, ma'am. Over to you now.
Parika, before that, I would like to welcome Justice Sandeep Mehta, who has joined us just now. Welcome, sir. Yes.
Good evening. Honorable Justice Carol, Justice Mehta, Justice Palo, and all the other dignitaries here and people who have been patiently listening to all of us through the day. It's been a privilege to be called to express my views on this aspect, especially when I was listening to the speakers from the morning, starting from Justice Kaul, of course, who's passionate about mediation and who said we have to think about different perspectives, to Geeta Ramseshan, who was talking about inequalities and inequities and all that, and Madam Giribala Singh, who was talking about culture, and Jawad and the rest of them talking about commercial aspects. So, through the day when I was listening to it, what I thought was that ultimately, what is mediation? Mediation is building comfort. Mediation is building courage for the parties to make their own decision. Until now, they have not taken any responsibility. They have asked somebody else to take the responsibility of making a decision for their problem. They don't deal with their problem. They ask somebody else to deal with it. And that is why they are not happy. But in mediation, they have to take the problem in their hands, weigh the possibilities and make a decision. And so they take ownership over the decision. And that is why we say whatever agreement comes in mediation is a workable decision. I have always been fascinated by mediation. People who know me know that I'm passionate about mediation. But what has fascinated me is the behavior of parties. And recently, in a couple of sessions of training that I had to do, I was thinking about this, and I was thinking that though we talk so much about what are the roots of conflict and behavior or perspectives and all that, ultimately, the three factors that really make up a conflict is personality, perspectives, and positions. It depends on the personality of the person. It depends on what kind of perspectives, as Justice Kaul was saying, because how I appreciate something, how I see something, how I hear something, gives me an interpretation, and based on my conditioning, based on how I assess certain things, my personality, or a challenge to my dignity, challenge to my respect, I try to be defensive. And so I feel that personalities and perspectives play a great role in putting up positions, that is, setting up goals, emotions that arise out of it, or the stand that I take when I am in disagreement with somebody. Recently, when I was reading something, it was very nice to see that the word dukkha that we normally use, we think it is sorrow or unhappiness or pain or something less. But apparently, Vatsayana has defined it as frustration of one's plans. And I think that really summarizes what mediation and family and matrimonial disputes is about. I just want to cite a couple of examples before I go into what I want to say. I remember there was a family partition mediation of a prime property in Chennai. And all the siblings were very well placed. Like one is a commissioner, one is the director and all that. And this lady who had filed for partition, apparently, when she was born, her father was told by the astrologer that because of her horoscope, something would happen to the father. And so she was given away to the cook with some money to be taken away from the family house. Actually, she was well educated. She had married into a very good family in Bangalore. She was well placed. But after the parents' death, she filed for partition. And when it was referred for mediation, the only thing she told me was, I don't want a share in the property. I want to be recognized as the daughter of so-and-so, which had not, even her lawyer did not know why she had filed. And only when I started talking to her, I realized that. So these are things that come out in mediation, their innermost concerns, their innermost, as Iram was saying, their underlying issues. What is it that really causes them that pain, causes them that frustration of whatever they had? Similarly, I remember there was I go to the other extreme where there was a custody matter between the father and the maternal grandmother, where the mother had died of a cerebral thrombosis. And they belonged to different faiths. So the grandmother was accusing the son-in-law of not having lived as a person of that faith he had converted to. And so she had taken the child and gone away. Normally, I don't like children in the mediation center, but because a child was there and just to keep her occupied, I gave her a few color pens and a paper and I said, just draw. I'm going to talk to your grandmother and your father. And she was sitting there drawing. And then when I looked at it, I found she had drawn a house. On one side, she had drawn a male figure. On another side, she had drawn an old woman. And I asked her, why did you do this? I mean, what is it? She said, I want both of them in my life. It was as simple as that. And nobody understood that. And if I had not asked a child to make the drawing, I don't know why I did it, but because I had asked the child to make the drawing, I realized what the child wanted. and I was able to take it from there. So I want to say that basically, I mean, these are just extreme examples. There have been examples where family fights over family businesses, and the eldest son says, when I was young, I was denied a chocolate and my youngest brother was given. Because of that, I will not give him to anything. I mean, it's as simple as a chocolate which was denied to him when he was age 10. Or at times it will be a child. I mean, when the parents were fighting over a divorce and about the property they had bought when they were married. And I find the daughter, accidentally, the mother said that I need this house because my daughter has a padded room. Then I asked her why. She said she's self-inflicting. Then when I spoke to the daughter, I found out that she had been sexually abused by the father. And so she was hurting herself because her mother wouldn't listen to her. And when I asked the mother said, she was a bank officer. She said, I've taken loans and I need to repay. So I'll address that later. I need to worry about the financial angle. So even the lawyer at that point did not know what was a situation. So I'm just telling you these examples to say that there are so many concerns, so many anxieties that bother these people, and it is in their innermost being, which they may even not be aware of. So how to engage them, how to bring them to that comfort level? If you look at it, of course, I said about personalities and perspectives. I think for what we have to understand is the mind state of the mediator and the mind state of the parties. As Iram was saying, that it's not just a 40 hours training that will equip us to deal with these people. We need to be constantly aware, we need to constantly update, and we need to care for those people. Only if we are able to care for them, they understand that they can share their innermost concerns. And if looking at barely at what is mind states, I would say partly it is how we are habituated to thinking, our conditioning, our culture, how we interpret things. And more than that, although we say free will and volition because we want to make our own decisions, we want the freedom to make our own decisions, ultimately it is because of this habits and the conditioning that we choose a certain kind of action. And so when we are talking to parties, we have to understand what are the layers that they have covered themselves with when they are presenting a particular narrative. Most of the time, they may know it is not the real narrative, but they want to believe in it because that gives them comfort. So in a way, it is a kind of recognition, helping them to recognize what is the situation. It is also helping them to move beyond that, beyond whatever is occupying them, to the extent that they will have to move beyond their comfort zone to see what is really hurting them. It's like asking a patient, say a person has gangrene and the doctor says you have to get this limb amputated. Surely he's going to say, no, it's my hand, I want to save it. But then amputating that part may be better. But how do you make him understand? It's when the doctor explains what will happen. So somewhere along the line, removing those layers and getting there and helping them to understand what are the possibilities. So this is totally multi-layered, much more than what is happening in other mediations. And the kind of nurturing that the mediator has to do. It's not only addressing the pride. We generally say, oh, they are egoistic. It's not just egoistic. Somewhere along the line, their plans have been frustrated, their pride has been hurt, their respect has been foiled. So somewhere they want, the emotions that come out of it is because they themselves don't know how to express how hurt they are. So unless we find out what has wounded them, and apparently when I was reading about mediations in China, they said, usually, of course, even in our culture, we have that, of course, it's an Eastern tradition mostly. That they have to respect their elders. So there it is more evaluative. And if the elders make a particular suggestion, they accept it. And in a way, it is face-saving. So we have to understand this nurturing by the mediator has to be to address the pride that has been hurt, to address the face-saving that would be necessary, and to sort of respect where they are coming from, to understand why they are making that particular proposition. So it is both for the mediator and for the parties, it is not only reflection of the act, it is reflection on the act also. So when we go back after mediation, it is good to reflect on whatever happened that day before we come to the next session to help them. And also ask them to reflect on whatever they have said so that they will be able to come up with some suggestions or able to think about something which is different. So on the whole, I think mediation in matrimonial and family disputes, especially now after the equal, especially for Hindus, after the equal rights for women have come about. See, there is a culture where the father, a lot is done for the woman when she gets married, and the brother has to keep doing for so many of the functions. So sometimes the families really cannot afford to split the property and give her an equal share. And because of this, of course, I'm not saying that it shouldn't be done, but today, because of that, a lot of women have come out to file for partition, and because of it, the relationship with their siblings have also been hurt. So to that extent, because there are a lot of family businesses also where the women have a share. So we have to understand that there is some, that what we do in mediation in family and matrimonial disputes has to be to balance not just the power, balance the relationship, and balance the kind of action that they can take. We also have to see whether the collaboration is authentic. Whatever they are trying to do is meaningful to further the relationship. We also have to help them to find out how their projections are conditioning them or making them interpret in a particular way, or how their anxiety may be displaced or may have some reason and how they can overcome that. So all this sort of creates a chaos, and how we move beyond that chaos to bring order is what the mediator does. And so I think basically what we have to do in matrimonial or family mediation is today, as a mediator, as a person who takes responsibility to show a mirror to them, to help them to move beyond whatever is hurting them or frustrating them, to help them understand that this is the situation, or as J. Krishnamurti says, this is what is. So you have to understand what is a reality and move beyond that. And to that extent, we have to understand that this engagement that is done by the mediator and helping the parties to engage with the mediator and with each other has to involve not only understanding of the mindsets, but also has to enable a constructive dialogue. Unless the dialogue is constructive, they will not be able to understand the perspectives of each other. And more important is, once we understand the perspectives, we'll be able to help them with how they have to comprehend the particular situation or the relationship. So with Einstein's E is equal to MC squared, I think we can say it's mind states plus constructive dialogue and comprehension, which will make engagement. And that is a thought I would like to leave with all of you, to say that, is it enough just to be trained for 40 hours and to think that we are helping parties to, we are reaching out to parties to talk to them? We need much more than that. We need to understand the perspectives. We need to understand, we may differ with them, but we need to understand why they have those perspectives, and we need to help them, to give them the comfort and the courage to move on. So thank you.
Thank you, madam.
Thank you so much, ma'am, for taking this discussion forward and highlighting some very crucial points on the issue, such as behavior, personality, and perspective of the parties, which are integral parts for smooth mediation and constructive dialogue. Now, I would like to invite our special guest, Dr. Pramila Acharya, to share her knowledge of the field. We welcome you, ma'am. The virtual platform is yours.
Thank you, Parika. My warm good evening to all. Honorable Chair, Honorable Mr. Justice Sanjay Karol, Chief Justice, Patna High Court, Honorable Co-Chair, Mr. Sandeep Mehta, Judge, Rajasthan High Court, Honorable Srimati Justice Anjuli Palo, Judge, Madhya Pradesh High Court, eminent speakers, Ma'am Ramanathan and Iram Majid, and all the participants who are joining us to this conference. In fact, I am privileged to be part of this August gathering. I am grateful to Faculty of Law, University of Delhi, Delhi School of Public Policy and Governance, Institution of Eminence, University of Delhi, and MCPC, Mediation and Conciliation Project Committee, Supreme Court of India, and organizers of this conference. Actually, since morning, I'm hearing such eminent speakers and with such great learnings. I can say that I am grateful to Ashutosh Mishra sir, who had given me this opportunity to be a part of this conference, because I've learned a lot since morning. And ma'am from Ma'am Uma and Ma'am Iram Majid, I know they are my gurus, and what should I say about that? But still, they are Ma'am Uma scholars, great scholar in mythology related to law and all. And Iram Majid has such a great vast experience in this field. So I will not speak much on that because both the speakers have touched each and every topic, each and everything in this. So I will just say that the subject of this session seems little, very interesting. When we talk about matrimonial disputes, it seems very interesting, at least at the first flush. However, the fact remains that more you do such kind of mediations practically, the more one realizes that it is the toughest form of mediation, toughest form of litigation. One has to be very, very, very sensitive to handle these kind of mediation matrimonial disputes. And maybe reason ma'am has already explained that people are highly emotionally charged. Iram Majid emphasized very beautifully on this, that in these kind of matrimonial disputes, these are family disputes, people are always emotionally charged, maybe any kind of emotion. And we have to very carefully handle their emotions, very sensitively, because we can't touch them directly. We can't touch their emotions directly. We have to be very, we have a framework. We should have a very good framework to acknowledge, to address their emotion, what they want to come up with. Because it's very, very easy to say that go for divorce, go for Section 9, go for custody. But when we handle disputes in mediation on these aspects, I will explain it with a short example of my own mediation. In early 30s, husband and wife were fighting with each other, with all blame games and all claims, counterclaims and all, everything was going on. And I was, at the end, I was not able to, I just realized that I have to refer back this mediation to Honorable Court again. But at the last moment, the girl, their child, girl child, who was, I think, 4 or 5 years, she was peeping out from that door and she entered. And she automatically pulled the chair and sit aside the father. And father, the expressions, while the girl entered and the expressions changed, both husband and wife turned into, a little smile on their face, and they were just forgetting everything which they were fighting for. And the girl just sat nearby the father and touched her father. And father was not only the father, but I was also a little, I can't explain those expressions. The girl started talking to her father, Papa, aap mere liye chocolate laye hain, Papa. And after 5 minutes and 5 to 7 minutes, the mediation turned into a very, very, realistic film scene. That ended up into a reunion of family because of that girl's emotions, because of that girl's touch. So we need to have a different knowledge to understand the language of the parties, different body language, different gestures, the emotion of the compassion, the affection, the love. We need to understand. We need to understand the expression of aggression also, because in I think 50% of cases, I can say practically by my own experience, then that the inner thing is completely entirely different from what they are showing. When we are sitting in mediation, initially they are showing that they're against each other and they can't live with each other. But gradually, when we give them sessions after sessions, we gradually be together with them, they give you a very different feeling inside. And we have to understand the feeling inside there. So as a mediator, if I have those skills with me, I can understand that what they are trying to say. This is for this reason. I think everybody is agreeing for that. That apart from 40 hours trainings, a mediator who is handling family matters, matrimonial, they need some specific training for that. And I would recommend that for these kind of mediations, when we are handling relationship, we are handling emotions, we are handling every kind of aggression and all, we need something little extra from what we are getting from 40 hours training. And at this stage, I think I would suggest this will be my very humble suggestion to every mediation center, that we can have our elders who have the experience to resolving these kind of disputes since long. They have a rich experience in family handling family disputes and all. We can call them, we can train them, we can make our support system with us, and of course with the requisite training which I'm asking for, because it's different. When you are handling a commercial dispute, you can handle anything, because there is no question of culture, because there is no question of religion, because there is no question of any local thing. But we can't do it in a general way. In matrimonial disputes, we have to be very sensitive, very stick to our religion. We need to see the culture of the parties. We need to see the religion of the parties. We need to see the internal criteria of the parties to look to each other with a different scenario. So in this conference, after learning so many things from all the eminent speakers, my request would be that we have to involve such people who are having not only mediators, not only lawyers, not only the senior persons, but senior citizens who are having the experience of these kind of handling these kind of experiences in their family. And as rightly said, Ma'am Kiran Gupta, that the compassion and the affection and all, we are really very difficult. And the expression of Kiran Gupta Ma'am was automatically showing that she's keen to handle this, to learn about this, and to know about the mediation aspect and role of in matrimonial disputes. So I will end up with this, that in the morning somebody quoted, जिंदगी में कुछ ऐसा करो कि हवा भी चलती रहे और दिया भी जलता रहे. As a mediators, we have to do this. We have to maintain the dignity of the parties. We have to maintain the balance, as ma'am said, that we have to maintain the balance between the egos, between the needs, between the internal interests of the parties. Thank you so much. I'm really thankful to all the organizers of this conference for giving me this opportunity to speak before such eminent speakers. Thank you all.
Thank you so much, ma'am, for sharing your valuable insights with all of us, emphasizing on the benefits and relevance of mediation, which has to be dealt with in a careful and sensitive manner in emotionally charged matrimonial disputes. Now, since Iram ma'am's session was interrupted due to a technical glitch, ma'am, we offer you the platform again for 2 minutes to continue with your insights on the topic, if you would like to.
Oh, I'm so touched. Thank you so much, Parika, for again giving me this opportunity. I'm sorry, first of all, being this tribe and the glitch. So see, I have nothing to say more after Uma ma'am and Pramila has mentioned. The only thing which I was telling you that time, that on the scale of emotions, negative and positive, that's what I was telling you. The survey was conducted, and the US result I will not tell you. First, I will tell you that what in India they said that, okay, if there is on 5, if there is 4 negative and 1 positive in a matrimonial thing, I will be able to stay with my husband. And I asked other, this different generation people, they said 2 to 3, this will be the ratio. And then the result in the US was, you will be amazed to know the ratio with the negative and positive in a matrimonial tie-up, that was 1:1. And that's where we are lacking, 1:1. If 1 positive, then 1 negative. It should not be in the sequence, but yes, that much of appreciation the parties required from their opposite spouse. And that was we are lacking. We are not giving that 1:1, but we are happy in 4:1 also. And that is what we are doing. We are dragging dead bodies, relations of these dead bodies on our head every day. And we are dealing in mediation with those dead relationships where we have 4:1, positive, 4 negative, and 1 positive. See, that's what I say. And that we don't understand that what the parties are going through, how emotionally they are charged, what is there in their psychology. Some people are committing suicide if they are not going through with the mediation. So we need to have skills to understand that what is the orientation of the parties, 4:1 or 1:1. And we have to give that to the parties by understanding their underlying interest, what is going in their subconscious, what is there in their mind. So we have to find out that. We have to go deep down and beyond the conscious mind. We have to enter into the subconscious mind to take out the structure of the conflict and bring it on the table and show it to the people. That's what we need. And for that, 40 hours training, as everybody said, not possible, not enough to say. And if I have been in the Hong Kong and other places, they are providing, the ministries of justice in those countries, they are providing different trainings. If suppose investor state mediation, different training, cross culture, different training, handling emotions and mediations, different training. So what I urge, because we have 3 eminent judges, and who can change in their mediation center this thing, just not 40 hours training. I urge all of you that please, we need 3 more days training to handling emotions, how to understand that, and how to serve this community more on a different level. This is what I urge. We need to integrate NLP. We need to integrate how to understand the language, hypnotic language, meta models, and different aspects. So we need to revise the curriculum. We need to add on more for these disputes. And I hope that this panel discussion should create a roadmap for the matrimonial disputes, how to handle that. And we could generate some good curriculum also. We can add on some trainings into this by the court and its mediation. Thank you so much. This is what's from my side.
Thank you so much, ma'am, for your inputs based on your own professional experiences, acquainting us with the harsh realities of mediation. Now, I would like to invite the co-chair for our session, Honorable Justice Anjuli Palo, Judge, Madhya Pradesh High Court, to share her knowledge on the issue and further enrich the discussion. We welcome you, ma'am. The virtual platform is open for your lordship.
Okay. My warm good evening to everybody. Importance of mediation is not a new subject for us. We all are aware about it. We know that 2 important pillars of Indian societies are family and marriage. Marriage is the process by which 2 people make their relationship public, official, and permanent. The universality of marriage within different society and cultures is attributed to the many basic social and personal functions for which it provides structure. It is the joining of 2 people in a bond that is presumed to last until death, but in practice, it is often cut short by separation, dissolution, or other types of disputes. Today, alternative methods of resolving matrimonial disputes are very significant in saving family system, which also saves times and money, such as mediation when there is no agreement between the parties on a topic. Discussion turns into a dispute, argument, which is turned result in unresolved discrepancies and ultimate dispute. We are now normally taking view that endeavor should be taken to promote conciliation and secure speedy settlement of dispute relating to matrimonial and family dispute. Huge number of cases are originate due to egos, differences in temperament, lifestyle, opinion, thoughts, etc. Then majority is coming to the court to get redressal. Mediation is the effective alternative remedy since it focuses on the non-coercive and consensual process. Nowadays, we feel that mediation is becoming a popular technique. Law Commission of India in its reports had emphasized that while dealing with disputes of family, the court should adopt an approach radically different from that it adopted in ordinary civil proceedings, and that it should make reasonable efforts for settlement before the commencement of the trial. Further, it is also the constitutional mandate for speedy disposal of such disputes and to grant quick justice to the litigants. The civil courts also insist to the parties to settle their disputes for partition, easementary rights, boundary disputes through mediation. Similarly, the family courts also prefers that the matrimonial disputes be resolved through mediation. We have experienced that sometimes petty issues were involved in between the parties. The mediation process provided them a platform to talk freely, explain themselves, and also identify the main problems in their relationship. By protecting confidentiality, it is an easy way to sort out the problems among parties by talking and deliberating. The mediator, by making a party agree on any decision, should always consider the best interests of the parties. Mediation allows them to avoid the high financial and emotional cost of their litigation. because all relationship problems arose from poor communication. Mediation is a forum in which a neutral mediator facilitates parties to avoid the risk of trial and decreases the stressful conflict. In last decades, as my early speaker spoke, that in our social system, the society has given more importance to settle the family and matrimonial disputes through our elders and heads of the society. Society also opted to settle the family and matrimonial disputes by way of Gram Panchayat. We cannot ignore that the matrimonial disputes harm the mental status and future of the children. A research by Baker McKenzie in 2004 reported that children of divorce show higher level of externalizing behaviors which are aggressive, problematic, and impulsive in nature. They show internalizing behaviors such as depression, anxiety, and withdrawal as well. Mediation more often than not result in joint custody benefiting the children with a continued future with both parents. When the parties go beyond aggression, it is much more a comfortable alternative compared to appearing before a judge. Mediation could be a best and effective way to resolve the family disputes and bring the parties in win-win situation. Thank you for involving me in this kind of program. Thank you again.
Thank you so much, Your Lordship, for comprehensively apprising us about the entire process of mediation and its importance with respect to the time, effort, and the cost that it saves, especially in family disputes. We hope that endeavors would be taken to promote this alternate mode of resolution. Now, I would like to humbly invite the esteemed co-chair for today's session, Honorable Justice Mr. Sandeep Mehta, Judge, Rajasthan High Court, to enlighten us with his words. It is an honor to have you here with us. The virtual platform is open for your lordship now.
Thank you, Parika. My Lords, Honorable Justice Karol, Sister Justice Anjuli Palo, distinguished speakers, I am first of all thankful to the Delhi University and the Supreme Court MCPC for having invited me on this virtual platform on this important topic of mediation and its role in family disputes and matrimonial disputes. I'll frankly concede that I am one of those few of the participants who has not had the good fortune of having had that training, the formal training, I would say, but informally, I have had some experiences in the subject of mediation, which I would like to share with this gathering. Since we are already running out of time, I'll just share my 3 experiences which I consider are really relevant for the discussion at hand. The first instance I recollect is during my lawyer days. We have been, for the present, focusing purely on matrimonial disputes, but there is yet another stream of litigation which has cropped up in the recent times. That is the litigation between the parents and the children owing to the Senior Citizens Maintenance Act. Now, I was engaged in one such dispute when I was a lawyer. The application had been filed by the father, and he was pleading for the ouster of the son, the only son from the residential premises. So the son approached me and I talked to him, asked him as to what actually was the background of the dispute. He said, sir, there is no difference whatsoever between my parents and myself. Probably because of some incident, their emotions were hurt and they have been misguided into filing this application. So I told my client that on the next day, when we enter the court, the first thing you will do is go ahead, touch your father's feet and tell him, I am sorry. And that power of seeking Kshama from your elders was immediately, the effect was immediately visible in the court, that both father and son started crying, they embraced each other, and the matter was settled. So, as Madam Ramanathan has said, that the importance of perceptions and emotions, how you treat them in a mediation, that is very important. The second incident which I'll be sharing is probably the highlight of my experience at mediation. The matter came up in the court wherein the spouses were fighting over a right to residence in the shared household. The husband and the wife were embroiled in as many as 12 to 13 cases owing to matrimonial disputes, which were pending for almost 8 to 9 years. One of the orders which was passed by the competent court in the Domestic Violence Act proceedings came before me, and the husband and wife were both present in the court. I like to vividly recollect the experiences which I had while intervening in that matter. Straight off, the thought came that why not attempt mediation? So the lawyers told me, sir, we have already attempted mediation in the district court, in the magistrate court, in the sessions court, and once even in the high court, but all failed. So I thought that why shouldn't I make an attempt? The husband and wife, the one important fact was that they did not have any child, no offspring from the marriage. So I first asked the wife as to what she precisely wanted. She said, I don't have any problem at all. He should give me, I am a Rajput lady. I am not going to remarry. I should be given a place to reside and a reasonable sum of money so that I can maintain myself. Then I asked the husband that why you are doing this, why you are continuing this litigation, why don't you agree to her offer? So the husband said, she is demanding too much. Then again, I reverted back to the lady. And she said that the man has a small house, little distance from the center of the city. He can give me that, and he can give me a particular amount, and I'll be happy. Then I asked the husband whether he is prepared for that. His outright reaction was no. The next question I put to the husband was that, how long have you been fighting? He said, that is almost 8 to 9 years. How much amount have you paid in fees to lawyers? Must be running into lakhs. Then the next suggestion next picture I showed to the man was that, do you know that with this state of affairs, how long you will continue to fight? Maybe another 5 years, 10 years. And how much amount will you pay the lawyers? He was little shaken. Then I asked him that your wife already has a right of residence in your house. What is the value of the house? So I was told that it is around about 1.5 crores. And because of that order of right of residence, there had been physical fights between the wife and the mother-in-law and couple of more ladies who were residing with the husband, maybe his bua or something like that. And cases of assault and beating had also been registered. So I told him that what is more important, finding a peace of mind, getting your property freed from this interference, or this amount of 15 lakh odd she's asking in a house, which she's otherwise also entitled to. As I told him that despite the fact that the mediation has failed, you just think over these things. You just keep on churning these facts which the court has told you, and come back after a few days. One stark observation: the husband was there in the court with his mother and his bua, and the lady, of course, was there. And all the ladies were wearing dark colored clothes. On the next day, I also told the lady that your demand seems to be a little high. You also please think of reducing it a little bit. You are not peaceful with this fight. So a little bit of consideration in money may settle the things and may provide you a way out of this unhappy situation. On the next day, the husband came and said, I am ready to part with the house. Please request her to consider reducing the amount which she is demanding. and the lady immediately agreed. I immediately fixed the matter on the next day and asked them to come out with the agreement. And the best part of the observation which I could make in the court was that on the next day, all the ladies were wearing colored clothes. They were bright and cheerful. In those proceedings before the High Court, which were arising out of an offshoot of the domestic violence application, the entire dispute was settled. Almost 12 litigations which were pending for 8 to 9 years. They were finished by the single order. The husband and wife parted ways. Of course, that was unfortunate, but we could not save it. The writing was on the wall. Now, the question which arises is that this was a very simple scenario which the court created before the parties. Why couldn't the mediator do it? What was the difference? Why the parties had to fight for 9-10 years and indulge in so many cases before they could be shown the correct picture? That is for the academics, academicians, and the scholars to find out where the mediators are not able to deliver the goods, but the court-initiated mediations often succeed better. The third incident, a very small incident, an application for pre-arrest bail came up in the court. It was pending for almost 8 months. And in the previous proceedings, the girl had demanded a sum of rupees 80 lakhs for settlement. The boy as well as the girl, both were IT professionals. They were doing very well. So again, the mediation proceedings had failed. Again, I took it as a challenge and thought, just give it a shot. So I asked the girl, what are you going to gain if this boy goes behind the bars? So the immediate reaction was, no, sir, he has spoiled my life, this, that. So then I told her the next fact. All right, I will reject his application for anticipatory bail. Tomorrow he will surrender before my magistrate and he will be released on bail. What difference would it make? He still will not go behind bars. And do you know how long will it take for you to even make an attempt to get him punished? The boy was all along saying, I have no problem with the girl. I am still ready to resume the matrimony. He was very hesitant on the proposal of divorcing the girl, despite the fact that the FIR had been lodged. So then I told the girl, you just think over it. We'll post the matter after lunch. And you just think over it that this case, even if the bail application is decided today against the accused, your criminal case will carry on for almost 10-12 years. By that time, you will be past the age of remarriage and all will be lost. And the August gathering will be surprised to know that in the post-lunch session, the girl came up and told that I don't want a single penny. What I want is my documents should be returned immediately and I should get a decree of divorce in 7 days. And that precisely was the order passed, that they should file an application under section 13B. The period of 6 months would be relaxed and the family court will pass the order. So by that simple intervention, the things were settled. So my submission, with whatever limited experience I have in the matters of mediation, my thinking is that the different kind of training, the different kind of perspective while handling the matrimonial matters needs to be inculcated in the mediators so that we can have more fruitful results to this wonderful mode of dispute resolution. Thank you. Namaskar.
Thank you so much, Your Lordship, for offering wonderful insights in the field of mediation and how to better implement it in today's society, drawing on your various relevant professional experiences. Now, I would like to humbly invite the respected chair for today's session, Honorable Mr. Justice Sanjay Karol, Chief Justice, Patna High Court. It is an honor to have you here with us. The virtual platform is open for Your Lordship now.
Thank you, Ms. Gupta. Good evening, ladies and gentlemen. On the panel, We have Ms. Dr. Professor Gupta, Ms. Majid, Ms. Ramanathan, Dr. Acharya, my esteemed sister, Honorable Justice Palo, and my esteemed brother, Honorable Justice Sandeep Mehta. Being the last speaker and that too at the fag end in the session, we are already running over time. I can only do no more than say I agree with all of them. There cannot be any difference. We don't need a mediation on that because the issue is so sensitive and we are all alive to it. And we are in total agreement with the views expressed by all of you. May I just only add 2-3 things. To begin with, I must thank the organizers and giving us this great opportunity. I believe that the others are also online, and I must also thank them for being with us at this point in time. They are tired. They would be definitely tired. I must thank Faculty of Law, University of Delhi, Delhi School of Public Policy and Governance, Institution of Eminence, and the Mediation and Conciliation Project Committee, Hon'ble, the Supreme Court of India. Before I forget, I must also request the panelists, not only the panelists, but also the organizers, to shift this platform from digital to physical in Bihar. I welcome you, all of you, to come to Patna, and I welcome all of you, be our guest. Moving forward, I must say one thing, that laws are already in place, mechanism is already in place. Only thing is whether we have the will to implement. That's really what is, in my considered view, required. The issue in hand is role of mediation in family and matrimonial disputes. Family disputes can be with regard to interpersonal relationship, father and son, mother and daughter, husband and wife. And it can be matrimonial dispute, it can be inheritance-related disputes and issues, and it can be business-related issues. And as far as the matrimonial is concerned, of course, there can be interpersonal between the spouses, it can be amongst the children, and it can be also, as someone mentioned, amongst the elders and the spouses. But let me tell you that the dispute is no longer related to dowry, so to say, the traditional sense, what it used to be at one point of time. It has expanded. I will just give you 3 illustrations when I move on further. We must, while agreeing with my astral speakers and more specifically Madam Ramanathan, we must be not only gender neutral, but also gender sensitive. That is the need of the hour. That is one big challenge, I think, the mediators and the whole justice delivery system has to deal with. Also, in my considered view, and I've been very, very categorical about it, we are, the whole approach of mediation is looked upon as though it is metro specific. It is not so. We are dealing with more than 4 crore cases which are pending in India. And therefore, we have to travel beyond the metros, because originally this concept of mediation, it was all along there in our ethos and in our system. But somehow we have not been able to get this idea from the out of the mind of the general people, that is the stakeholders. Everyone feels that it has been thrusted upon us from outside. It has been brought from US and UK, and it has been thrusted upon us. So we have to be, as stakeholders, also be sensitized about this aspect, and we have to also change our language, if I may use that expression, so if I may be allowed to say so, in undertaking this process of mediation. Because everything, when we talk of mediation, is only in English language. The concepts are foreign, they are alien, they are not specific to the needs of the people. After all, we cannot forget that India is not Delhi, Bombay, and Madras. It is the hinterland, so to say, where the major litigation is there. I cannot agree any more than, yes, we have to adopt an individual and case-specific approach in dealing with the issues which arise for consideration. Now, I'll cut short and say what are the challenges before us. The challenges before us is the huge pendency and how to curtail that, use mediation as a tool or a mechanism to reduce that pendency. Not only that, very few we see when we compare the population of India and the population of the cases which are pending in the court, we find that there are huge disputes which are lying, so to say, on the flanks, about to be filed at any point of time. So rather, I would not only say that we should concentrate on mediation insofar as pending matters are concerned, but also pre-litigation mediation is what need to be focused at this point in time. One huge challenge also comes from the bar. We'll have to find solutions. We have to sensitize the bar. And we also have to sensitize the litigant, because the litigant at one point of time has given fee. For him, he doesn't know this concept of process of mediation, or the existence or establishment of this process of mediation. So he wants, what do you say in colloquial language, a fence law. He doesn't want a compromise. He's looking for a fence law. He's come to court, he's paid fee. And the lawyer, unfortunately, will not allow the dispute to be resolved, because his bread and butter, so to say, is based on his litigant coming to him on daily basis. Now, this is the hard reality. Let us not shy away from it. And therefore, this is a huge challenge. And as I said, that lack of sensitization and sensitiveness on the part of the judges also, it needs to be done, because they are looking for judgments which would help them get their ACRs recorded. So that's one big challenge. Now, coming to solutions, I'll be very brief. I've already said that we have to sensitize both the litigant as also the bar. We have to pursue this program in the language of the litigant and also in the language of the stakeholder, that is the bar and the bench. And we have to, in my considered view, we have also to expand what you call the concept of a mediator. You need not necessarily have trained mediators. You have to, now time has come for us to engage the other stakeholders in the society, as it was in earlier days. Panch Parmeshwar, we all used to go there. Now, therefore, my considered view would be, I'm talking as a panelist, to also expand and engage a lot of NGOs and community-based associations, and communities must be engaged and involved. That has the advantage of a deterrent of litigation also, arising of a dispute also, in fact. And we must have focus on pre-litigation mediation. The Legal Services Authority needs to have a more proactive approach and a role to say in this. I will give you 3 instances now, which I've been referring to earlier. The expanding nature of disputes. Believe you me when I'm saying so, I have come across an agreement where 2 young people, today India is just youth who are in the age group of just 30% of India is just about 16 to 20 years of age. and 50% of India is just about less than 40, if I'm correct on the figures, approximately that much. So they have new disputes now which are emerging. And I know of a case where the dispute was that two young children, a boy and a girl, they were living together, and they had thought of getting married. So they had kept a pet, and the dispute was when they parted, they decided not to settle down permanently in life. They reduced into an agreement who will take care of the pet. So the pet was a dispute between the two young children. And the agreement was that for 6 months they would, each one of them would keep. So when they parted, then there was a lot of counseling which was done. And the matter had come to such a fore that it was about to be taken to the court. And incidentally, I was knowing one of the child. So I counseled him, others also counseled him, and eventually the matter was resolved with the pet being custody of the pet being handed over to one of the persons. So these are the expanding areas of disputes which we have to take care of. That is one. Another thing is, I'll tell you, when I say that we have to curtail litigation, I come from Simla, and we had expanded the role of Legal Services Authority there, and I was the chairman of the Legal Services Authority. And there is one district, Kullu, in Himachal Pradesh. Now, when we expanded the activity of Legal Services Authority and made people realize their rights and under the various laws, and especially the matrimonial laws, we found that suddenly there was a huge spurt of matrimonial litigation which had come to the court. So we studied the reason. Now the reason was this, that there was a system of the parties' illiteracy was there, and the parties would go to the court, and the stamp vendor there or the deed writer would just on a piece of paper type out the divorce, the terms of the divorce, not only the terms of the agreement, and they give them a divorce by just reducing it to writing without the judicatory process of the court. So when suddenly we made them realize that they have been not guided properly, we found that not only there was proper, the parties took recourse to law, but also it helped resolve disputes of inheritance, because though that paper was just nothing but just a piece of paper which had to be shredded. So a lot of disputes got resolved. Another thing, these are the two instances which I wanted to give. I can see that out of 7 panelists, 5 are women. Madam, I must take pride on 2 facts. I must use this opportunity to let you know that on the last examination which we have held for the judicial services, entry of into the Bihar Judicial Service, we have selected and appointed 341 candidates, the biggest batch ever anywhere in the country. And out of that, 154 are women. I must share that with you.
Sir, we take the baton in this case, the leading baton. In our last, sorry to interrupt, sir, in our last recruitment, we had 124 out of 190.
Oh, great. Congratulations.
Sorry to interrupt, sir. Sorry to interrupt. I apologize. But this, I just couldn't get it low. Let it go, sir.
But in a place like Bihar, to get 154 judicial officers,
incredible.
Officers,
incredible.
Is
incredible, absolutely.
And one thing I must tell you, all the lady panelists, please. In Bihar, when we are talking of socio-economic background, let me tell you one thing. During COVID, I got a study conducted. 40 lakh migrants returned to Bihar. And all of us were holed up in 4 walls of rooms. 1 room, 2 rooms, 3 rooms, depending upon the houses. And all of us were traumatized. All of us required counseling. Certainly, let us admit that. And I got a study conducted as to whether there was any increase in crime against women or not. And my research showed that there was no increase of crime, corresponding increase of crime. So then I was not satisfied. I said that let me just go and check up whether it is being reported. There can be cases, or there should be cases where crime is, I mean, it's difficult to fathom that 40 lakh people have come back home, all of us hold up, and there's no increase in crime against women. And I then got a study conducted that it was not a case that women were not reporting, or that they were reporting and it was not registered. So Bihar, let me tell you, so to say, is one place where women in particular are respected. The disputes are maybe there of matrimonial of the nature of matrimony, but they are less. They are more arising out of sharing of property and land, because we have less land. Huge 1/10 of India lives in Bihar, and we have the mass land is very, very less as compared to Madhya Pradesh, from where brother comes, or other places. So one dispute, because we have been not able to settle one dispute with regard to the land, it raises multiple disputes, more so in relation to the crime, which is hardcore crime. So that is what I need not emphasize, the need and the importance of mediation. And it has to be, as I said, fast-tracked. It has to be gender neutral and also gender sensitive. And we must engage all the stakeholders, and more so community-based stakeholders. So with these words, thank you very much for your time, please. Thank you.
Thank you so much, Your Lordship, for apprising us with certain intricate details of mediation and its ever-expanding meaning, beautifully capturing the entire essence of the discussion, coupled with, of course, your valuable suggestions, such as the need for being more gender neutral, more gender sensitive for better justice delivery. With this, we reach the end of the session. It was indeed a thought-provoking one and instilled more mindfulness on the issue of mediation. Now, I would like to call upon my respected moderator, Professor Kiran Gupta, to share concluding remarks and present the vote of thanks for the session. Over to you, ma'am.
Thanks, Parika. Thanks to all the speakers. As I have said in the very beginning, I'm repeating the same, that marriage is an institution, and it is an institution of trust, tolerance, and mutual understanding. Matrimonial relationship demands mutual trust, regard, love, and affection with reasonable adjustment between the parties. Adjustment has to be there. Husband and wife need not to agree on every issue. They have the right to disagree. Conflicts in matrimonial relationship are normal and expected. They are bound to happen. They are bound to be there because two persons who live in a different family, different culture, maybe different following different practices, they are united. So there need to be bound to be some conflict between them. Marital conflicts not confined to difference of opinion, rather it is a series of poorly handled events which deeply damage the marital relationship. These small disputes, if they are not properly handled, they will result in disruption of the marital relation. So the need is to handle these disputes between the parties to the marriage properly on time. Divorce terminates marital union and dissolves bond of matrimony between married couples. The resolution of family conflict requires special emotions and procedure which should be designed to help people in trouble to reconcile and resolve their differences and where necessary to obtain assistance. Conserve a marriage and not to disrupt the family life is the rule and should be the rule, because disruption of married life affect mostly the children. The most adverse effect it has is on the children of the parties. So this is the need of the hour, that we should resolve the matrimonial dispute in time and amicably. And it is irrespective of the fact whether the dissolution of that dispute will result in resolution of that dispute will result in conservation of the marriage or disruption of the marriage. Of course, our try should be, our intention should be to retain, to protect, to conserve the marriage. But if it is not possible, let it be dissolved. But the dispute must be resolved. Continuation of the dispute will keep on damaging the parties, the society, the children of the family, and all the members of the family. With these words, since we are lagging behind the time, I would like to express my gratitude to all the speakers of the day who have given their deep insight into the importance of mediation or the role of mediation in resolving family and matrimonial disputes. Honorable Justice Sanjay Carol ji, the chair of the session, I fully agree with you that there is a need to sensitize the stakeholders, the parties, the litigant, the judges, the lawyers, as well as the mediators. Without that, mediation will be useless, will have no effect. We must sensitize them. We must see to it that lawyers are not misusing their knowledge for the sake of earning money and misguiding the litigants. In most of the cases, it is seen that mediation fails because of the lawyers. Whenever a matrimonial dispute arose, chota sa matrimonial dispute, choti si fight, and a party visit a lawyer, the lawyer will give a long list, you can say a package of cases he is going to file on behalf of the wife or on behalf of the husband. And he will say that I will file these and these cases, and the package is 5 lakhs. Pay me 2 lakhs 50,000 today and 2 lakhs 50,000 after the decision of the case, and you will get the relief. And these are the cases I will file, and everything will be taken care of by the lawyers. They don't even want mediation, and they don't even actually permit the litigants to resolve their dispute by mediation. That mindset of the lawyer needed to be changed, especially in matrimonial cases. I fully agree with you for that, sir, and we are very thankful that you have given such a deep insight into the process of mediation and the need of mediation and how it will solve the problem of the society, especially the matrimonial problem. Honorable Justice Sandeep Mehta ji, your advice to us are very, very important. I again fully agree with you that we say that we are sending the matrimonial dispute for pre-litigation mediation, but that is not sufficient. The reason, there are lots of reasons. We should not, all of us know why it failed. But when the judge takes up the role of mediator, I have seen it in number of cases. The disputes are resolved within 1 or 2 hearings. it may be that people rely more on judges than on mediator. Or maybe the mediators are not performing their duty properly. And that is why the litigants have no faith on them. But the moment the judge intervenes, within 2 or 3 hearings, the parties reconcile their dispute and the case is solved. Honorable Justice Anjuli Palo ji, we are highly thankful to you for your insightful discourse which you have given to us. You have comprehensively apprised us about the process of mediation and how it is beneficial for us, the benefit of mediation, that it is cost effective, it is a consensual process, it is a easy way to sort out the differences. We are highly thankful to all our 3 guest speakers of the day, Madam Iram Majid ji, Madam Ramanathan, who has shared, both of them have shared their personal experiences with us. And you know, we learn more from experiences than from theory. So the insight, you can say, the exposure of the actual process of mediation and comprehensively apprising us about those aspects, the in-depth discussion you have made about your real experiences has really benefited us and will definitely benefit our student also. Dr. Pramila Acharya ji, we are highly thankful to you for your valuable, insightful discourse. Thank you all the speakers, the co-chairs, the chair, Justice Sanjay Kero. We are highly obliged to you. Thank you. Thanks.
Thank you, all of you, please. Thank you.
Thank you, sir. I again thank all of you for joining us today and making the session a huge success. Thank you so much. And now I would request all the participants to kindly fill up the feedback form for the certificates. Thank you and have a very good day.